Three, two, one, go. Hi, my name is Carl Burkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been a family attorney for about 8 years now, and I want to help you make law easy by talking about the changes that have come about in the last year in the family law world, specifically regarding custody, visitation, and guardianship. So I'm talking today about 112.5, Title 43, Section 112.5. This is the title that talks about when a parent is fit or unfit for custody, visitation, or guardianship of a child. Um, I've been talking a lot about how this statute changes in subparagraphs C and D because it carves out specific scenarios where a parent is unfit to have custody, visitation, or guardianship. These are scenarios regarding um, abuse, stalking, harassment, substance abuse, and coercive controlling acts. That's what I'm going to talk about today because this is such a huge change in how these cases are uh, being prosecuted because or not prosecuted, this isn't a criminal thing, but how they're being pursued, because it used to be that psychological abuse is very hard to define. It's very hard to quantify, and it's really hard to get the courts to pay attention to unless it's being accompanied by some physical abuse. It's something that I've known countless family attorneys who have had to look at clients and say, unfortunately, I can't put a picture of your emotional bruises and your emotional scars on the stand like I can a physical one. And the law didn't really make any protections for this or allowances for this. The law never said, hey, if someone's maybe not hitting a child, but telling a child that they're terrible every day and making the child feel like they don't deserve to be alive, well, at least they're not hitting the child. That's what this law is changing now. Psychological and pattern-based abuse is now legally relevant to these proceedings, and not that it wasn't relevant before, but now it's been actually specifically defined and carved out to where if you're able to show that a parent is perpetrating these coercive and controlling, demeaning acts, then that triggers the rebuttable presumption. Then that makes them unfit to have custody. It makes them unfit to have visitation that's unsupervised. It makes them unfit to have guardianship. This is going to be a huge game changer in domestic violence situations because so often there's so many domestic violence situations where there's never a scar or a bruise that's left, but it still is incredibly detrimental to everyone involved. So if you're in these situations, please give me a call. I want to go over your evidence and I want to see what we can do to build this case for you. My name is Carl Burkhead. I'm with Worth Law Office and I want to help you make law easy. Thank you.